Hello, everybody, and welcome to today's session, which is going to be looking at employment tribunals in the care sector. We're going to be focusing on insights, trends, and practical strategies for HR and people managers. The session will be recorded, and there will be a chance to ask Q&As, question and answers using the Q&A box. So if you have got a question, just please pop it in the Q&A box, and we will answer it at the end of the session. Okay, so just by way of introduction, my name is Olivia Toulson and I'm a partner in the employment team at Birketts. I'm based in our Cambridge office and I have lots of experience handling employment tribunal litigation for all sorts of different types of claims, as well as advising on day-to-day employment matters. And I have a particular interest in the healthcare sector. I'm joined today by Rebecca Hughes, who is an associate based in our Ipswich team. She regularly advises clients and particularly care homes and other care sector organisations on their employment tribunal litigation, day-to-day employment work, and navigating the intricacies of many of the particular issues that arise in the care sector, such as holiday pay, GP disputes, and compliance with the working time regulations. So just to tell you a little bit about Birketts, for those of you that don't know, we are a full service UK top 50 law firm. So we have over 1,000 people now, and that's 140, over 140 partners, I should say, and over 700 lawyers and other legal professionals. We have a heritage that spans over 160 years, and we're based in 7 offices across the UK. So real strength and depth. We have an employment team that has over 40 employment lawyers in it. So lots of people here to help you if needed. Right, so if we move on to tell you a little bit about some of the services that we can offer in the employment team. We have an immigration team that focuses exclusively on immigration matters and helping get employees in and out of the UK. And again, they have a particular focus on the care sector. We also have an independent investigations team who are able to go in, do really complex investigations, help out with businesses that need that level of support. We have an HR consultancy practice, a shaping excellence practice, which is dedicated to providing trainers, so meeting all of your training needs, right through from HR professionals through to training line managers on every topic you can imagine, from performance management right through to sort of TUPE and holiday and disciplinaries and investigations, all of that kind of work. And finally, we also have an employee incentives team. All of those tricky questions that you might have about shares and share schemes, they're all can be answered by our employee incentives team. We also have an app. An employment app that I'll leave the slide on there for a few moments so you can scan the QR code and download it. It's a really fantastic piece of really fantastic resource that will enable you to keep up to date with any day-to-day bulletins or updates that come through, read articles, and generally access lots of information about the events that we're running. Easily searchable, really easy to use. So do please have a look at that when you've got a minute. All right then, just to tell you a little bit more about what today's talk is going to be focusing on. So as I mentioned at the outset, we are going to be looking at focusing particularly on the care sector and looking at practical strategies for managing employment tribunal litigation. And we're also going to be looking at a national survey that we carried out, particularly or focused on a number of different sectors, but for today's purposes, focusing on the survey that we undertook in the care sector. exploring the methodology, looking at some of the results of the survey that we carried out, and then thinking about some of the tips and tactics of handling employment tribunal claims. So what can we learn from the survey to help us manage employment tribunal claims and resolve those tricky disputes that we always have to deal with? All right. So in terms of the national survey that we undertook, businesses and people management teams are facing really challenging times at the moment in the employment law landscape. It's never a dull moment in employment law, so we have been able to take some of the announcements last week and give you a bit more information about those hot off the press. So essentially, first of all, most organisations now are experiencing a real increase in claims. Mounting numbers of employment tribunal claims, a 14% increase between April 2023 to March 2024 compared with the preceding year, and that's set against a backdrop of a system that's really under strain at the moment. We're handling employment tribunal claims in this office where hearings are not being listed now until sort of 2028, even heard rumours of 2029. So really difficult to manage and deal with these claims quickly. Added to that, you'll have no doubt seen in the press lots of publicity around the Employment Rights Bill. Up until last week, we all thought that this was going to introduce day one unfair dismissal rights, but that's changed now. The government are saying that is going to, instead of day one rights, be a qualifying period that will be reduced from the current 2 years down to 6 months. So that means that somebody's only going to have worked for you for 6 months in order to obtain unfair dismissal rights, the right not to be unfairly dismissed. We don't know, but we suspect that this will come into force in April 2026, so next year. And the reason for that really is that the sort of ping pong that was going back and forth between the House of Commons and the House of Lords was really pushing back the timetable, and the government were keen to kind of bring some of this law onto the statute books much sooner. So that was the trade-off, really. So it's likely to be introduced 1st of April next year. There is the potential or discussions around potential removal of the unfair dismissal cap, the element that relates to 12 months pay. So at the moment, there are effectively 2 caps that apply to unfair dismissal claims. If you earn less than the current absolute cap, so it's about 118,000 at the moment, then your losses for a straightforward unfair dismissal claim are capped at 12 months pay. If you earn more than 118,000, then your maximum that you can be awarded is the upper cap, which is about 118,000. Now that's a cap that moves on an annual, or is reviewed and potentially increased on an annual basis. So it's much more positive news for employers, but there's still going to be an inevitable increase in the number of unfair dismissal claims. And it also means that employers are really going to have to start focusing on proactive performance management during that 6-month period, because it's a bit of extra time, but it's not lots of extra time. So it's still really important to get that initial period, the initial 6-month period of performance management and managing probationary periods right. So if we take a look at our survey methodology, so what did we do? So we commissioned a national survey in collaboration with an organisation called Opinion Matters, really to look at uncovering trends in the employment tribunal claims system over the last 24 months. We focused in really on three three particular sectors, and these are sectors that really tend to experience a lot of litigation for a variety of reasons. And those were hospitality and leisure, care, and manufacturing. So we focused our questions on those sectors, but we also asked other organisations as well, and they tended to be organisations with more than 1,000 staff, not sector specific. We surveyed 500 HR professionals in England and Wales, most of them, around about 400, from organisations employing over 1,000 or more people. We did this really to obtain really exclusive insights into the true cost of for businesses of handling grievances, disciplinaries, and employment tribunal litigation. So it's really essential information to help employers understand how they can limit their risks, fully understand the cost of litigation, both financially and from a reputational impact for the care community. So if we move on to the next slide, I'm now going to hand over to Rebecca, who is going to look at some of the survey results and practical tips.
Thank you, Olivia. So the first statistic I'm going to take you to is what is the volume of claims that were brought? So when we asked this question, the results for our survey stated that 60% had dealt with between 26 to 50 employment tribunal claims in the previous 24 months in the care sector, with an average being 39 employment tribunal claims across the sector, which is broadly in line with the average across all of the other sectors, which was 40 claims in the previous 24 months. It's quite staggering, how many claims that the care sectors and the other sectors that we surveyed are having to deal with on average. With 39 employment tribunal claims doesn't take into account all of the grievances and all of the time spent on the disciplinaries, the grievances, and the other internal processes. So then moving on to the next statistic. So once we'd decided and we got the statistics on what the volume of claims brought were, we then looked at what are the most common claims that are being brought within those claims that were brought. And as you'll see on the slide, that wide-ranging results, but in the care sector, the most common claims that were reported were unfair dismissal, including constructive dismissal, disability discrimination, wrongful dismissal, and holiday pay. Now, this suggests that the high turnover rate within the care sector, alongside legacy holiday pay claims, which have been brought by care sector workers following the recent case law in this area, in particular the Supreme Court ruling on the part-year workers, may have led to a kind of an artificial bump in the number of holiday pay claims. And I'd suggest in a few years, once those claims have worked their way through the tribunal, that actually we might see less holiday pay claims. But with the introduction of the 6-month qualifying period, I'd anticipate to see even more unfair dismissal claims. And what's interesting to me when I look at these statistics is actually, although we see more unfair dismissal claims, it's seldom that I ever see a standard unfair dismissal or constructive unfair dismissal claim alone anymore. What we're tending to see here at Birketts is an unfair dismissal claim tagged along with something else, often disability discrimination. And therefore, for me, it's unsurprising that the percentage of unfair dismissal claims and the disability discrimination claims are actually quite similar, unfair dismissal being 27% and disability discrimination being 23%, because I'd often find a disability discrimination claim tagged on with an unfair dismissal claim. And as you'll all be aware, if you've got a disability discrimination claim, the cap for unfair dismissal compensation comes off. And so I think often that is, they're brought strategically together. We often see claims being brought on multiple legal grounds brought against the care sector, often because of high turnover, And normally we're seeing claimants don't meet that 2-year qualifying period for the unfair dismissal claim. And so what they'll do is claimants will often bring a claim for an automatic unfair dismissal reason, such as whistleblowing, as well as discrimination or victimisation, because they don't require the minimum periods of service. Also, unfair dismissal attracts limited compensation for those that are on lower salaries, because at the moment it's currently capped at, the lower of, and being 52-week salary is more likely for most of those in the care sector. In addition, claims for discrimination or whistleblowing are often more complex to handle. They will almost always be listed as one preliminary hearing to determine issues such as whether aspects of the claim are out of time. I see quite often that managers are named in these claims as well. So there'll be the question of which claim is against which respondent, or any of the claims out of time against any of the respondents. And they can often then eke up a cost in defending those claims when you've got multiple preliminary hearings listed. With the Employment Rights Bill reducing the qualifying period to 6 months, what we might see is, yes, an increase in unfair dismissal claims, but a reduction in the more complex claims, because ultimately, often I see claims called discrimination or called whistleblowing where actually the employee, the claimant, just feels aggrieved that they were unfairly dismissed and have named it something else. So we might see more straightforward claims for unfair dismissal, less complex claims, and therefore these will be listed quicker for less days and hopefully with a reduced cost. But I still anticipate we'll see an increase in claims generally, and particularly for unfair dismissal. It will also be very important to be mindful and diarise that 6-month period and take into account that additional statutory week that gets added on. So it's not actually 6 months, it's 6 months minus a week. And I'd be suggesting any of my clients to take at least 2 weeks off in case of absence and other things like that. So really looking at getting to the 5-month mark and assessing someone's employment, so you're well clear of that 6-month getting that unfair dismissal rights. And then the next statistic I wanted to look at is looking at, our survey results suggest that employers lack faith in the ability of early conciliation service to help that resolve employment tribunal claims. Now, in the care sector, respondents gave the following reasons for not using the service. So over half, 54%, reported that they had not used early conciliation because they felt either it would not resolve the issue or it would be a waste of time. 44% of respondents surveyed indicated that it was because they believed that they could win the case. And 36% indicated that it was because they were not willing to negotiate with a claimant, compared with 32% across other sectors. Now, as most of you will have seen, from Monday this week, the early conciliation period has now doubled. So this has increased from 6 weeks to 12 weeks. And what this means is ACAS, where we're seeing, respondents might not be contacted by ACAS until, say, 4 or 5 weeks into the early conciliation period, given their backlog and obviously their workload. They've looked to introduce it and double this period to give ACAS longer to conciliate. But what that really means for respondents and employers is when something's resolved and when a matter is dealt with, or you've been dismissed and the appeal's been resolved, previously you could have waited, say, 6 months, and if a claim didn't land on your desk, you could be pretty certain that matter had resolved itself. Whereas now I'm seeing clients that are getting the claim, 9 months later than the initial incident. And that was before the ACAS period has increased by 6 weeks. Now with the backlog of tribunals processing claims and sending them out, coupled with the increase of the early conciliation period, if you're making decisions and say if you're dismissing someone and the manager says, well, when can we look to hire a replacement, or when can we be certain this matter's resolved? Actually, now we've got a 12-week early conciliation period. You could be looking at some claims landing on your door, a year later, particularly when we get the increase of time limits, which is being proposed under the Employment Rights Bill. So although yes, it will be good to have a little bit longer for those claims that maybe you are interested in settling and that you're looking to negotiate, actually all it's going to mean for a lot of employers is for those that you're not feeling as if you'd like to conciliate on, or you're not wanting to settle because of, say, merits, you're going to have to wait even longer before you actually receive that claim. And often memories fade of those that were involved. So it is something to bear in mind. Now I want to look at when do claims settle. So we had a look at when claims were settled for those surveyed that were brought. And a quarter, so 25% of care sector respondents reported that claims were settled at last minute, the day before the final hearing. And what that really means is all of the time and effort and energy has already been put into preparing the defence, doing disclosure, having witnesses involved, drafting witness statements. All the legal fees have been incurred, and almost always the brief fee will have been incurred at this point for counsel's attendance, at least at the first day of the hearing, and their preparation before the claim is settled. Now, what I'd be suggesting is, with claims, you look at early on, is this a case that we actually want to settle? Is this a claim that has merits, or maybe there is some reputational risk here? And do we want to look at an early settlement where it's going to be cost effective, maybe not too early so that you don't give the opinion that if people bring claims you want to settle, but potentially earlier, particularly earlier than the brief fees incurred, and look at strategically, is there something you should be doing in managing your claims and managing your settlement? And those that are getting to the day before the final hearing, are there claims that will be successful? And then actually, could you be more robust and go to the final hearing and defend the claim in order to have a win, have that on the record that you will defend claims if they're brought without merit, rather than settling the day before once all the costs and time have been incurred and getting to that point. Interestingly, almost all of the claims settled, or the large majority, were after the witness statements were drafted, which is interesting because actually that's where a lot of the work is incurred and a lot of the time for the organisation. And then if we look at the slide that's here, we looked at, a lot of the claims in the care sector settled via ACAS, during the tribunal process. We've got 31% here being settled, and 30% of claims that we surveyed were settled, at the full tribunal hearing, where the business was settled. So when we're looking at resolving those claims, it's interesting that the care sector claims going to final hearing and actually being successful than the other sectors, which in contrast was 25.5%. So we're seeing a lot of claims going a bit further in the care sector, but still quite a lot being settled last minute at the door. And then when we looked at when do they settle further, we looked at over a quarter, so 28% of respondents reported that claims against care sectors were settled during the final hearing, which is obviously significantly higher than the rate across all sectors. So again, a lot of claims settling the day before, and if not, then going into the final hearing and settling. I won't take you through all the statistics because you'll have a link to the report, and so you can see all of the different figures, but I just found this statistic interesting because we're looking again at very late settlement, a lot of claims actually going all the way to final hearing and not being resolved until the final hearing, and again a lot after the exchange of witness statements. So then what we looked at, when do they settle, and and how they settled, we then looked at why do they settle? So why are care sector businesses settling their claims? And interestingly, and I think unsurprisingly, witness credibility was the most common reason for organisations in the care sector settling claims, with costs coming in closely behind. So I think unsurprising to statistics. What I find with my care sector clients, and when we're looking at their tribunal claims, is often with the delay in the backlog in tribunals, and sometimes claims don't get to final hearing until, say, 4 or 5 years after the incident, after a number of preliminary hearings and matters, that actually a lot of the staff have left. The manager that maybe made the decision or has been named as a respondent no longer works for the organisation, given the high turnover in this sector. And so employers struggle to get witnesses to attend, and if they do, they're concerned with their credibility and their memory given the incident that happened so long ago. Now, what I do, what a strategy that I often talk to my clients about, is where this is a claim a case where it's a dismissal where someone's raised discrimination or whistleblowing, or a matter that you think this is something that I could see going to the tribunal, is early on getting an initial high-level statement from those witnesses. One, because it will help you in assessing witness credibility and determining early on if you've got an issue with a witness. I've been out at a client's premises taking statements and heard all sorts for witnesses, and then reporting back to HR to question whether actually we think this witness is someone we'd like to call, given maybe some of the comments they've said to me when taking statements. So making that assessment really early on does impact merits and can help with the strategy going forward with the claim. So, that coupled with the fact that they're probably unlikely to be giving evidence within the next 3 years and memories do fade, it is often something that I'd be suggesting, even just a high level, bullet points of the key facts of what they remember, so that when you come to assessing credibility, assessing who you want to call and whether they're going to be giving evidence, you've got a good framework in place. And also then later, when you're taking the substantive statement with the documents, you've got a good framework and you've got a good few points to jog their memory. It will make it much easier later, I promise, than it would trying to ask someone to remember something that happened 4 years ago. But I think unsurprisingly, and that witness credibility being such a main reason for settling claims, because I do see this and witnesses being kind of one of those, or you might have 4 witnesses and 2 no longer work there by the time you get to the case. And I think with the delay in the tribunals and the changes being made by Labour, I anticipate this just becoming more of a problem, not less. And then we looked at, what prevents claims. So our survey indicated that on average, almost half, so 48% of employment tribunal claims brought against care businesses in the previous 24 months were preceded by a grievance process. And so what this means is employers have knowledge that this matter might end up in a tribunal claim, and then can put the work in to ensure they do what they can to reduce the risk and increase their merits. I won't take you too much through this, because Olivia will be talking about grievances and disciplinaries later. But as you can see, for the care sector, you've got workloads, working conditions and discrimination being some of the grievances which predated the claims. And again, just showing how many, 48% of grievances of claims were preceded by grievance. And I'd anticipate that a number of the other claims are preceded by dismissals as well. And then finally, for me, for this section, we looked at how long HR actually spent handling tribunal claims. Now, this ignores all of the time spent on the grievances, the disciplinaries, the DSARs that I'm sure followed, and the actual witnesses' time spent, the solicitors' time spent, and the costs. But just for the HR time spent managing claims, the survey showed that on average, 5 working weeks were spent on care businesses on managing tribunal claims, and that's in addition to their day-to-day work and all of the other responsibilities they have. That's quite a staggering amount of time spent by HR, given that it's not just HR that spends time on handling the tribunal claims, as I'm sure all of you will be well aware. And so then I'm going to hand you to Olivia, who's going to cover some grievances, disciplinaries, and a bit more statistics from the report.
Thanks very much, Rebecca. So we're now going to shine a bit of a spotlight on grievance cases. So our survey indicates that on average, almost half of employment tribunal claims brought against care businesses in the previous 24 months were preceded by a grievance process. So of those surveyed, the most common categories of grievances that were dealt with by care organisations in the last couple of years were related to workload and work conditions. So we can see on the slide there that 25% related to workload, 25% related to work conditions. So this this really could just reflect ongoing issues in the sector with recruitment, staff retention, existing staff bearing having to carry additional levels of work because they are working in organisations which have possibly a depleted workforce. So really interesting statistics there on what some of the main complaints were that were being brought. Interestingly, a little bit further down the chart we've got sort of management of performance, harassment, stress, bullying. In other organisations, stress, bullying, harassment, discrimination, they tend to be a little bit more little bit further up the chart, but yeah, interesting that a lot of the focus for care sector employees is around working conditions and levels of work. So if we just move on to the next slide, please. In relation to disciplinaries, those surveyed from the care sector dealt with 53 disciplinary matters in the previous 2 years. So this is actually significantly higher than the average of all sectors that we surveyed, which was 36%. So 37 disciplinaries over the space of 2 years. The most common type of disciplinary matter that led to dismissal was committing acts of discrimination, so acts of discrimination against fellow colleagues, residents of other individuals perhaps, and dishonesty, timekeeping, and sort of external matters. So that might be something that happened in a private life that perhaps infringes on their ability to perform their role. And also bullying featured highly as well in terms of reasons for disciplinary action in the care sector. And so if we move on to the next slide. So in terms of the average, those surveyed in the care sector had dealt with 47 grievances in the previous 24 months. Again, this is considerably higher than the average for all sectors, which came in at 29% lower, so 35 cases. So it really does go to show how much time is being spent by line managers, by HR professionals, by people managers in trying to resolve grievance cases. So if we take on to the next slide. So in terms of what HR professionals felt needed, line managers needed more support with, HR professionals identified areas in the last 12 months in which their line managers needed increased training and support. And that was particularly in relation to managing grievances. So obviously with a lot of line managers, this is not managing grievance, dealing with a grievance isn't their day-to-day job. You know, their day-to-day job is focused on operational matters and dealing with a lot of the day-to-day responsibilities they have. So HR professionals identified that managing grievances is something that line managers really needed extra support with. In addition to that, identifying and understanding fair reasons for dismissal. So most of you on the webinar today will know that if you want to terminate somebody's employment, you need to have a fair reason, and typically that is going to be conduct or redundancy or capability or some other substantial reason or illegality. And we have to work out what process to follow based on what we think the potential reason for terminating their employment might be. So HR professionals identified that 28% of line managers needed some help and guidance around working out what fair reasons for dismissal might be. And then finally, handling difficult conversations. So lots of issues, I think it's fair to say, both in the care sector, but also across the board in all businesses, there's a real understanding that if you can nip things in the bud and have those difficult conversations earlier on, it really does help to stop things escalating to full-scale grievances and formal complaints. So again, it's not everybody is great at it, and so being able to give line managers the tools and the support in order to have those difficult conversations, particularly in relation to things like performance, or areas where somebody's not quite achieving the standards they need to achieve, then giving somebody the tools to help them with that really does help nip things in the bud. If we move on to the next slide, we're now going to look at some practical guidance on some particular areas of law where we can look at minimising the risk of potential claims and the risk of potential grievances and disciplinaries. And the first thing we're going to look at is the new duty. I say new, it's been in over a year now, actually. Duty on employers to take reasonable steps to prevent sexual harassment of their employees. So this new duty came into effect last year in October, 26th October 2024, under the Worker Protection Amendment of Equality Act 2010. And what it does is it places a new duty on employers to take reasonable steps to prevent sexual harassment of their employees in the course of their employment. And of course, in the course of their employment can mean not just during their 9 to 5 job on the premises, but it can also mean things like at the office Christmas party or the after work drinks, those extensions of employment where perhaps those lines become a little bit more blurred, are also areas where this new duty can bite. If the employer fails to comply with the new duty, then they potentially face an uplift of any compensation that was awarded to the employee by a tribunal of up to 25% if the employer is found to be in breach. The Equality and Human Rights Commission also has the power to take separate enforcement action against a company. So we see this, or we have seen this in the press, particularly in relation to McDonald's, but some of the larger organisations and the Equality and Human Rights Commission have gone in and done some investigations and ordered some training and required those companies to really step up their game and their practices in terms of making sure that employees know how to behave themselves in the workplace. Technical guidance was published last year, back in September, and an 8-step guide for employers was also published. Both of them are really helpful documents. They set out lots of examples about what employers should be doing in order, as a basic minimum, really, in order to prevent sexual harassment. Typically, this will include making sure that there is an anti-sexual harassment policy in place, making sure that everybody in the workforce has been trained so that they know what could constitute sexual harassment, and what they need to do if they see that taking place, how they should step in. It also makes clear that employers need to carry out a risk assessment, and says that employers will have failed in their duty or are likely to have failed in their duty if they haven't carried out this risk assessment. So that's just some of the examples of what employers need to do to make sure that they are complying with this duty. Labour have said that they will take steps to further strengthen the duty. So what they're planning on doing is, instead of the duty being limited to taking reasonable steps, they are going to make it a little bit more onerous by saying that employers must take all reasonable steps. So every potential reasonable step that can be thought of, employers need to take. They are also looking at reintroducing third-party harassment rights, so the right not to be harassed by a third party that might not, for example, be a fellow employee, could be contractor or customer or something like that, looking at reintroducing those obligations again. So if we move on to the next page. So in terms of key manager training and manager training and support areas, so the survey really identified that managers do need support in grievance handling, developing and formulating and following the correct process for termination of employment, and also having difficult conversations to improve workplace relationships. Diversity and inclusion is also another big area that was identified as where businesses needed support. So training, including equality, diversity, inclusion, and managing ill health to help foster fair and supportive workplaces. And then finally, continuous learning and accountability. So refreshed training aligned with policies promotes accountability and prepares managers for the tribunal scenario. So really key there to help ensure that managers are as well prepared as they can be if they ever need to go to an employment tribunal. And finally, just a quick checklist here from us in terms of making sure you manage the grievance process properly so that you put yourself in the best situation you can be if you do need to go to an employment tribunal. Our first top tip, of course, is follow your grievance procedure. Any tribunal is going to want to see that you've done that and that you've dealt with the grievance properly, you've listened to everything that the employee's got to say and they've followed the process. Grievances need to be dealt with in a quick, fair and confidential manner, and that really results in hopefully a win-win situation for everybody. So hopefully the idea of a grievance really is not a tick box exercise. It's meant to be to help try and resolve a complaint. So grievances that are dealt with quickly, fairly and confidentially hopefully will result in a win-win situation for everybody. You avoid a tribunal claim and you have a happier employee. It's really important to ensure that investigations are obviously impartial, that you've identified the right person to deal with the grievance, somebody that hasn't been previously involved and knows the parties for other reasons, and someone that's sufficiently senior to be able to make a decision. Ensuring, of course, that you've got a private hearing with an open discussion of the issue so that everybody says everything they want to say really in terms of what the issues were and what they're looking for by way of a resolution. You've got to communicate a decision in writing. So once you've heard everything investigated and come to a decision, that decision needs to be communicated in writing, and the right of appeal needs to be given, and that needs to be to any appeal needs to be directed to a more senior manager, so somebody that has got the ability to review the original decision and, if necessary, overturn it or change it in some way if needed. Of course, an individual has a right to be accompanied to a grievance hearing as part of the formal grievance procedure. So I'm now going to hand back over to Rebecca, who's going to talk a little bit more about tribunal strategy.
Thank you, Olivia. So I want to first just focus on a bit of the initial tribunal strategy. So when a claim lands on your desk or you're handed the claim by someone within the organisation, what are the first things you're doing and what are you thinking about? So my first thing that I would do and what I'd suggest clients do is look at time limits, look at any strategic method that can be used, look at what your strategy is going to be early on in this case. There will be that case that lands on your door and you kind of knew it was coming and the merits are not very good. Decide at that stage, is this a case that we want to look to settle early to save those costs, or actually is this a claim that strategically, because we know others are involved, because it might get out to the workforce, we want to take it further and we want to take a really robust approach? Are there parties named that could be removed? Could applications be made for further and better particulars? To develop that really early strategy and decision making and document that if possible to show that decision made early. As part of that early conciliation strategy, have a look at actually what's your best, worst, unlikely or reasonably likely outcome to this. So, when you're looking at what the basic award will be, how much compensation an individual may be claiming, what your injury to feeling, if any, awards might be, and what range that might be in. And assess early on, what is this actually going to cost, not just in legal fees, but in time, in the number of witnesses involved, in the length of the hearing, and of course, in the costs if you were to lose, or what a likely outcome looks like. Because if you do that really early on, that's going to really assist you in understanding internally what your strategy is. Now, your strategy might be, we have to go all the way. This claim has no merits, and it's really important to us that we show our workforce that we're robust in managing claims to strategically try and reduce the number of claims we're getting, because you might have had a sudden influx in claims, and that might be your strategic approach. But having an initial consideration of what that is going to be and deciding early on can really assist in reducing the cost later, particularly for those cases where maybe you're not looking to go all the way to final hearing. And then also evaluate your evidence and kind of your document management. So, what witnesses might you have? Have any of them left the business or given notice? How many versions of that appeal outcome letter or grievance outcome letter are there? Are there any internal comments from line managers or those which maybe say things you don't want them to say but would be disclosable? And what information is privileged, so you can protect that privileged information early on and make sure that you don't inadvertently waive privilege. So just a few initial considerations when you're looking at a claim, when it lands on your desk, when it lands and is handed to you, what is your strategy for this claim? And then moving on, the next stage as part of that strategic review is looking actually at pre-hearing applications. So if we look at the next slide, we've got a few initial applications that I want to talk you through. So the first application is a request for further and better particulars. Now, I often put this within the grounds of resistance and also make a separate application if it's appropriate. But what is the claim? Can you understand that claim? Does it really shout out at you, or do you need to ask for more information to understand what you're actually defending, and not guessing what you think the claim is? Because sometimes you might think the claimant is bringing more claims than they actually are, and you don't want to inadvertently give them extra claims if you can avoid it. So if you are requesting further and better particulars, really tailoring those questions to make sure they narrow down the issue for the claimant, and where possible you then don't get a 5-page response which then adds a number of new claims that you have to object to. So does that ET1 claim form, can you understand your claim? Do you understand what the claimant is claiming? Often I see claim forms with a few sentences of I was harassed, I was discriminated against, with very little detail, and you do need to put these in. And I'm finding more and more that these are becoming kind of almost part and parcel with the grounds of resistance, that you need to request more information, where often claimants are unrepresented in this sector. So the earlier you can make this, the better, particularly using it strategically when you don't want an argument to be made later. So if they haven't mentioned the appeal in the claim, and you're worried that the appeal might bring a claim in time where otherwise it'd be out of time, can you strategically use the request for further and better particulars to get them to confirm that's not involved without them kind of realizing, so that you can then look at actually when you get to the prelim and they try and raise it, saying, well, actually, you've already clarified that that's not in your case. So looking strategically at when this can be used and when it's needed, and the earlier the better. If you wait to the preliminary hearing, then the claimant's often going to just be talking at the judge about what their claim is, and that could result in actually a much wider claim and more allegations than maybe if you went down a route of targeted questions via a further and better particulars application or questions in your grounds. And then you're looking at strikeout applications, which I'll talk about a little bit in more detail in the next slide. But does this warrant a strikeout application of all or part of the claim? And is this on time limits or merits? If you think there's got some merit but low prospects, could you go for a deposit order? Often you'll go for a deposit order in the alternative when you're going for strikeout. Is this a claim where you want to put cost warnings forward? Often a very robust cost warnings letter, maybe a drop hands letter, to a claimant in the appropriate way, not too robust, but quite nice and firm with some of the key merits, and why you may go for costs can work really wonders. And I do see claimants then withdrawing claims following this. This needs to be used at the appropriate claims, and handled appropriately with references to independent legal advice if a party is unrepresented, but can really strategically be used. And then looking at unless orders for non-compliance with tribunal deadlines, orders, or just generally, do you need to make an unless order if you've not received the response to one of your earlier applications? So just really early on, and then routinely looking at your applications to make sure you're robustly handling and managing that claim, and not just letting it get all the way to the hearing before realizing that maybe actually you could have used one of these applications. And then moving on to look at striking out claims. Now, this is often a really useful tactic to be used for respondents or employers when you're looking at a claim. Now, often you might see a claim and think, well, on the face of this is in time, and so why would I go for strikeout? But actually, part of a claim might have no prospects, and so you could go for strikeout of an element of a claim. Sometimes that can reduce the timetabling from 6 days to 5 days or 4 days, and can save costs, but also can apply good pressure on the case itself and the case management. I see often in the care sector respondents being named as the company, but also a number of managers and investigators and decision makers. And a lot of the time, those claims are out of time against those individuals. So strategically, do you want to go for strikeout? So you've gone from 4 respondents or 5 respondents to 1 respondent. Is there part of a claim that could be struck out alongside that? And be mindful that what you're looking at is there no prospects of success? It's quite rare, in my view, that you would go for strikeout because a claim has been brought and being handled in a certain unreasonable or vexatious way. The bar's quite high, although there will be the appropriate case that comes up. Really, for me, the one that we see is the no reasonable prospects of success, and that can be merits, but also can be strikeout on the basis of time limits. So really reviewing at the outset, and then as the matter progresses, particularly once you've got an agreed list of issues, and saying, is there something here that can be done? Can we go for strikeout, and when is it appropriate? And then moving on to costs. Now, if you're looking at bringing a cost application, making a cost application, it's always best practice to have warnings, particularly when a party is not represented. You can go for costs on all of the claim, but you can also go for costs on part. So if a claim is then dropped later, or part of a claim is dropped later, or a claimant withdraws the claim quite late in the proceedings, consider when you go for costs. Now, this might be used tactically, and you might go in with a view that actually we know we're not going to get costs because the claimant won't have the funds to pay, but we're doing it to try and reduce the number of claims brought, or to assist a claimant maybe that's subject to a deposit order to withdraw that claim. But it can be used tactically, and there might be the appropriate case where you would also look to go for costs. As we know, in tribunals, unlike the civil court, costs don't follow the event. Costs are an exception, not the rule, but it doesn't mean it can't be used, and it doesn't mean you shouldn't be considering it when you're looking at your case management. I do sometimes see judges making decisions, and you can see that they're doing so on the basis they're hoping that the respondent won't go for costs. So reading the room is important, but also there are cases where it's important to go for costs, and you can get quite good cost results if you do so appropriately in the right case. And then looking at really the kind of risk of the claim and what you can do to reduce going to a final hearing and losing, or getting all the way and realizing you need to settle at the door because the merits weren't maybe what you thought they were. Now, as I've mentioned, that early triage and looking at the merits, limitations, and any legal arguments that can be made is really important. But then I would suggest having review periods for your claims. So I would suggest at the minimum disclosure. So once you've received the claimant's disclosure, this is a really good time to revisit that earlier strategy, You might have seen a document in the bundle that really reassesses the financial compensation. So, for example, the claimant provides medical evidence that shows that they've been diagnosed with something, they're now taking antidepressant, might increase that potential injury to feeling award that you were initially anticipating. So revisiting at that stage is really important. And having kind of a consistent approach across all of your cases, and maybe a flowchart or a checklist internally, so you know what you're doing when. And then I'd also suggest at the very minimum a review once witness statements have been exchanged and you've got the claimant's full story, full view, and at that point you'll also have had previously received disclosure. Then if you receive disclosure, or if you receive a witness statement and the claim looks even weaker and the evidence that they've been suggesting they may have, that covert recording they've alluded to, isn't disclosed or isn't in existence, at that point again, don't be afraid to challenge those weak claims and revisit any strategic management of the claim and any kind of applications you might want to make, or at that point you might want to revisit whether you need to do cross warnings and things like that. So it's really important, I think, to be consistently reviewing it, but having milestones where the claim could change. I think I've seen a couple of cases change following disclosure and witness statements, or at least slightly different view once you've seen, actually, is this all the claimant has? Is this all the documents we've got now? So I think it's really important to just always be alive to the fact that things do change and progress as the matter progresses. And also making sure you secure witness availability. I have had to make applications on behalf of clients because witnesses are no longer available on certain dates or things change. And so again, making sure you're consistently reviewing that, having those witnesses and those strong witnesses available and lined up, and keeping them in the loop as matters progress. You'd had a witness 3 years earlier that they need to give evidence at a tribunal, and then you reach out 3 years later and they no longer work there. They might be quite surprised to hear from you if you haven't kept them in touch. So again, just keeping an eye. And then just document prevention, that ongoing duty for disclosure is throughout the claim. So make sure once the claim lands, you are not sending further emails about it, which might be, not privileged and that might come out, or creating any new documents that again might need to be disclosable. So locking down your document management and taking those steps to make sure you're putting your best foot forward for your claims. And then finally, for me, setting an action plan. I'd suggest at the stage 12 months, but you're probably going to need to revisit that when when more claims are brought with all the new proposals that come in, and there might be more of a backlog. But every 12 months at least, you should be looking at your claim again and setting out an action plan for the next year. You might find that there's not many steps. I've got claims listed in 27, and that actually there isn't much to do in that 12 months, but it doesn't mean you should just leave the claim alone and wait for something to come in. At least every 12 months you should be reviewing your case and just checking there's nothing that you should be doing. You can't be preparing, or then there's no strategic correspondence that needs to go out. In addition to that, you might need to look at whether any training is needed or any policies need to be updated. Obviously, that can be helpful to show that you've taken steps following an event, but also is learning for new claims. So if you've got a claim and one of your weaknesses, your policy wasn't followed, or you don't have a good enough policy in place, then making that change following the claims to reduce the risk of future claims is really helpful. As Olivia mentioned, the managers need training and support. Also, witnesses and managers can attend the tribunals to watch a hearing, or could attend mock tribunals, and that might be really helpful in increasing their confidence in actually giving evidence, but also in when they're making their decisions, they can actually see that those decisions are the forefront of a tribunal and what questioning might look like. It might actually really help them in then doing that role and making that decision. And then tracking metrics. So, often I sit down with my clients after a win and we go, right, well, what have we learned? What are we going to do differently? And what are we going to implement? And what are those involved? What have they really learned? And sometimes getting takeaways from the managers and the witnesses involved, but also as an organisation, what have you learned? Where could you improve in the future? And if it's just that your policy works and it's great, that's wonderful. But I always find that there's at least one nugget that can be then passed on for future claims, which then means that you're learning, developing, and you might find that then easier to defend future claims, because ultimately as an organisation, if you're making steps, if you're managing performance, if you're dismissing for conduct, there will inevitably be claims. You can't help that, but you can learn from it and try and reduce it that way, as well as obviously taking those strategic steps. And so that concludes the main content for today. And so then we'll move on to any questions.
Thanks, Rebecca. I can see we've got a couple of questions that have come through. I'm going to take one in relation to compliance with the duty to prevent sexual harassment. The question is really around ensuring how can employers ensure compliance, and have there been any tribunal cases yet that have considered the new duty? So as I think I mentioned before, compliance, really the key things are to do your risk assessment, to make sure you've got a policy in place, and make sure you have put training in place for the workforce as well. In terms of whether there've been any cases, no, I haven't seen any cases come through yet, or any judgments come through yet that have looked at whether an employer has been fully compliant or partially compliant and decided whether to award an uplift or not yet. And I think that's really because, the duty has only been in force for a year now, and it does take time for these cases to work their way through the tribunal system. So I envisage that we will see we will see some decisions in the months to come.
Thank you. And I'm going to answer the question, how would you prepare cases given the current backlog and delays in the tribunal systems? So I think, again, when looking at preparing for a case, if you think this one might go to a tribunal, and particularly if you think this is not one that you're looking to settle and you want to take a robust approach to it, I think there's a couple of tips I'd advise my current clients, and I was actually advising someone on this yesterday. But actually, you'd be looking at, what documents have you got, and can you kind of put together a mini file of the key documents so that when it comes to it, you're not scrambling for inboxes for emails from 3 years ago or 2 years ago when you're looking to do disclosure. Have you got a central place where you can put kind of the key documents and the key emails to make that disclosure obligation less? As you're working on a case, you have them in your inbox, you've got all of the different versions. It's much easier while it's alive and you can remember what you did. The second is timelines. I love a timeline. When you get all the casework in and all the paperwork in from a client, and they've got a helpful timeline of all the steps that were taken, it's really helpful. Often we prepare the timeline for judges, and it's used in kind of part of that case management. And so having a timeline of what happened when and who did what can really help not just us as so your legal support, but internally when you're looking 3 years later at why you did this on this day, and you've noted that in your timeline someone was on holiday, or the grievance took X amount of time for these reasons. That's really helpful for reminding yourself what actually happened and when it happened and who was involved. And then also finally, I think really key, and one I really would implore those in the care sector particularly to be using, is skeleton witness statements, or witness statements of those that are leaving. So if you know someone is leaving the organisation and they're going to be a witness, they're a key decision maker in a claim that doesn't look as if it's going to settle, or even if it might, but you're worried that you might be too far apart, getting their statement while they're still employed and they're on the book per se, and they've got the duty to work for you and put that time in, and make sure they put the time in whilst they're still employed. Because when a witness no longer works for an organisation, it's hard to get them to actually put the time in to drafting the statement, to having the meetings with the lawyers, particularly during working hours, because they might have found a new job. Those really high up operation managers will have gone into a new care home, and as you know, they'll be extremely busy, and so they're going to struggle to put the proper time in that's needed to create that witness statement. So doing it before they leave, whilst they kind of still have to, even if they're on garden leave, they could still be doing that, is really key. And for those that aren't leaving, just make sure they note kind of their key thoughts at the time and the key steps they took. Note form is fine, bullet points fine. We don't need to have reference to a bundle that doesn't exist of documents, and be in the kind of format that we'd expect it to be submitted to a tribunal, but just enough down that when it comes 3 years later to then going through and formally taking their statement and finalising it, they've remembered what they needed to remember. And sometimes you take a witness through what they wrote and they go, oh yeah, I remember that now, and it can really be good at jogging their memory. So I think that's really important as well, because we are just seeing such a backlog in the claims being brought to final hearing, particularly those that are listed for longer, like discrimination. And people will forget what's happened 5 years ago. I mean, sometimes you struggle to remember what happened a few weeks ago, in the appropriate detail. And so having that note will really make a difference when you then later come to get that substantive statement.
All right. I think we've just got time for one more question, and that is a question around how managers can be best supported when handling disciplinaries and grievances. Um, and we touched on this earlier, and there's lots that can be done. It's not often part of a line manager's day-to-day responsibilities to spend the time investigating complaints and dealing with disciplinaries. So I suppose the first thing really is just, making sure that they do have the time and space to be able to carry out those duties effectively so that they can manage their workload and give the investigation the real sort of attention that it deserves. And also, HR's presence in terms of like coaching through any difficult conversations, helping to identify the right people to speak with, helping to carry out the sort of balancing exercise in terms of evidence and corroborating evidence, and really learning how much weight to give certain bits of information. I think that's as well as sort of training in terms of the types of questions to ask, focusing on opening questions before moving to sort of more focused closed questions, and also really sort of helping to set the scene so that the employee feels comfortable to be able to say everything they want to say, and really make sure that everything is thoroughly looked into. All right, I think that's probably all we've got time for today. Thank you very much to everybody who submitted questions. If we haven't answered your question, then a member of the Birketts team will be in touch with you to help you out and provide an answer if needed. All right, then that's it from us today. Thank you very much for joining us.
Thank you.